That's right. After hijab and halal, the latest controversy is over azaan or the use of loudspeakers. MNS chief Raj Thackeray may not be winning political seats, but he wants to get his name in the arc lights. So guess what? He's gone and set a deadline to for the ban of use of loudspeakers for azaan across Maharashtra. Similar calls are now being made by Hindutva groups in states like UP. All of this comes against the backdrop of a week where communal violence has taken place at Ram Navmi processions in at least half a dozen states. Our top story today is the spiral of hate. And then we're going to look at the big question: how do you stop the hate campaign? Take a look.
Hijab, halal, and now azaan. From Maharashtra to Karnataka to Uttar Pradesh, demands are being made to ban the use of loudspeaker for azaan. The call for prayer by mosques. Raj Thackeray, the Maharashtra Navnirman Sena Supremo, has issued a new threat. Giving an ultimatum, Raj Thackeray has said all loudspeakers in mosques in the state should be removed by May 3rd.
तुम्हाला जो काही नमाज पढायचा आहे, तुम्हाला जी काय अजान द्यायची आहे, घरामध्ये द्या. आणि जर सांगून जर समजा तुम्हाला समजत नसेल की हे भोंगे खाली उतरवा, तुम्ही आम्हाला विनाकारण त्रास देऊ नका, हे जर नीट सांगून समजत नसेल तर तुमच्या मशिदीच्या बाहेर आम्ही हनुमान चालीसा लावणार म्हणजे लावणार.
The Maharashtra Vikas Aghadi government in the state has played down Raj Thackeray's threat.
त्यांना फार महत्त्व देऊ नका. माझ्या दृष्टीने आज धनंजयची तब्येत ही जास्त महत्त्वाची आहे. दुसऱ्याही प्रश्नाची उत्तर मी योग्य वेळी देईल, त्याबद्दल काळजी करू नका. माझ्याकडे प्रत्येक प्रश्नाचे उत्तर आहे.
The MNS chief had made a similar threat a few days ago. After that, an MNS worker was arrested for playing Hanuman Chalisa on loudspeaker. The loudspeaker fire has reached Uttar Pradesh as well. In Aligarh, the ABVP has announced it will install loudspeakers at 21 crossings across the city to propagate Hinduism by playing the Hanuman Chalisa.
हमने अलीगढ़ के 21 चौराहों पर लाउडस्पीकर लगवाने की मांग की है. वहां पर हम हनुमान चालीसा एवं धार्मिक आयोजन पर होने वाले कार्यक्रमों के लिए उसमें यूज लेंगे. ऐसे 21 चौराहों की लिस्ट हमने एडीएम प्रशासन को दिया है.
In Prime Minister Narendra Modi's constituency, Varanasi, a group of people claim to have installed loudspeakers to sing Hanuman Chalisa. Other communities in the temple town have not raised any objection.
ये बदले की कोई भावना नहीं है. हम जब जागे तभी सवेरा वाली नीति पे चल रहे हैं. हमारे धर्म का पतन होता जा रहा था दिन प्रतिदिन.
हम सिर्फ एक ये मैसेज देना चाहते हैं कि भाई हम भी बजा सकते हैं. हमें भी किसी ने रोका नहीं है. किसी कोर्ट के आदेश की अवहेलना नहीं कर रहे हैं. तो अगर आप चाहते हैं कि हम भी ना बजाएं तो आपको भी ध्वनि कम करनी चाहिए. इससे दोनों लोग का सौहार्द बना रहेगा.
The divisive debate over azaan comes just days after communal violence broke out after Ram Navmi processions were targeted in many states. There has been a dramatic rise in hate speech as well. The frequent fights over religious practices are now threatening to harm social harmony in the country. Bureau Report, India Today.
How do you stop the hate? That's the question I want to raise tonight. We will have two aspects to it: the religious aspect and the legal aspect. I start with the legal aspect. Dushyant Dave, senior advocate, and Aryama Sundaram, senior advocate, join me. Both of them distinguished advocates of the Supreme Court. Let's talk about it. Dushyant Dave, how do you stop this spiraling hate campaign? We saw yesterday the Supreme Court suggest that they wanted state governments to act against hate speech. But it almost seems as if the Supreme Court itself is powerless to stop this spiraling communal violence, that they too have their limitations. Am I correct that the law has its limits, and that's what is reflected in the Supreme Court saying, look, it's for the state administrations to ensure action is taken against those who practice hate speech?
Well, the answer to that is yes and no. I think the Supreme Court, being the custodian of the fundamental rights of the citizens, has a great responsibility on its shoulders to protect the minority community in the country. And if the minority community is under threat because of the repeated hate speeches which are being, being used again and again by religious and political leaders, I think the Supreme Court has to step in, and Supreme Court has to send powerful message. Unless and until Supreme Court does that, I think it's going to be very, very difficult for us to really stop this kind of a menace. It is now unfortunately become a habit on the part of certain persons in politics and in religion. And the court, I think, must take cognizance of this. I would say...
No, Dushyant, just a minute. I just want to stop you to say, when you say court must take cognizance, when the Hindu Sena filed a counter appeal in the Supreme Court in the Hardwar hate speech case, the Hindu Sena had demanded that Muslim leaders should be arrested for hate speech. They said the speeches at their Dharam Sansad were made in response to attacks on Hindu culture. So the definition of hate speech is under question. The sense that the Hindu leaders say that these are one-sided, why should an Akbaruddin Owaisi also not be charged for hate speech, for example? Does the court have to do a delicate balancing act, or has it to send a strong message to all?
No. It must be a message to all. I mean, there's no question there is no doubt in my mind that if anybody from the minority community, including Mr. Owaisi, makes those provocative and hateful speeches, he must be, held accountable, and he must be proceeded with forthwith. I think the judges must do it, because ultimately what we are striving for is, communal harmony, a fraternity, which is our goal. It's a constitutional goal, and the court can't be a silent spectator when the court sees. Court has to take a judicial notice of the fact that the party in power is not interested in acting across the states, and therefore the judges will have to step in and stop all this kind of nonsense which is going on in society. And sooner the judges do it, I think the better it will be for our democracy, for our nation, for our people, and of course, rule of law.
Let's be clear, Aryama Sundaram. While Dushyant Dave says that the court cannot be a silent spectator, he believes that the center has been silent. The fact is, for example, these attacks that have taken place on during Ram Navami processions have taken place in BJP-ruled states like Gujarat and Madhya Pradesh. They've taken place in Congress-ruled states like a Rajasthan and a Jharkhand, where they share power. It's taken place in a Trinamool-ruled state like Bengal. Who is ultimately accountable? What can courts do? What can the law do? Section 153 says promoting enmity between different groups on grounds of religion. Section 295A, deliberate malicious acts intended to outrage religious feelings. All of these are bailable. Today you may arrest someone, whether it's a Mahant or a Maulvi who resorts to hate speech. Tomorrow they'll be out again.
Well, two things, Rajdeep. Let's first start with the first point. There's no such thing as saying that, hate speech against minorities and minorities being affected by it. A hate speech is a hate speech, whether given by a minority or a majority, as there are fundamentals on both sides of the fence. The point of the matter is this, and I say this is where the failing comes in. Hate speech itself is not referred to in the Indian Penal Code. What the Indian Penal Code refers to are various acts of creating communal disharmony, incitement to riots, is a case of disintegration, of speaking against the integrity of the country, etc. Now, very unfortunately, each one of these sections, some of which you yourself refer to now, carry very minor sentences, maximum 3 years or fine, not 3 years and fine, 3 years or fine. Many of these, therefore, bail becomes something which the courts normally give, because they treat it as an offense which is 3 years or fine. And they give bail in cases like that. Now, the fact of the matter is that courts, however much we may wish otherwise, the courts are also bound by the law. A court cannot turn around and say, in my view, this kind of incitement for religious divide, this kind of incitement to a communal divide is something which is so heinous, I'm going to punish you with life imprisonment. You cannot do that, because the Indian Penal Code and its sections say what the punishment is. However, what you can do is, if that incitement actually results in kinds of bodily harm or otherwise, then throw the book at them under other sections, whether it is murder, attempt to murder, whether it is grievous hurt, which carry much more stringent punishments. But I think legislation needs to be brought in to make these violations far more strictly dealt with and punishable with far more serious punishments.
And also,
and not be treated so lightly as to say, you know, in all the sections you said, should I tell you the maximum? I'm not keeping sedition here, but all the other sections you've referred to, the maximum sentence in any one of those sections, many of them it's 1 year, some of them it's months. In one, it is 3 years or I use the word or fine.
Can I just stop you? You know,
the problem is
Yes.
that what is the offense under the penal code is not the making of a hate speech. It really becomes making a speech which creates an incitement, which is intended to incite people into a divide.
Let me therefore
this
take
is
that
a
point.
very-
No, let me
and-
take
and the
that.
penal code
Sir,
doesn't
let me
define
take
hate
precisely that point, because the content of hate speech is also not clearly defined, Dushyant, the way under the law. Now, for example,
Except in the
Raj,
Supreme Court judgment,
Yes.
except in one Supreme Court judgment,
Yes.
the penal code nowhere refers to the word hate speech.
Right.
Hate speech per se
Yes.
is not an offense under the penal code, and the court cannot make it an offense. So it's no use blaming the court.
It's
Because
no-
the court is equally bound by the Constitution and the statutes. You
Sir-
cannot give a punishment different from what the statute says.
you know, but Dushyant, the way, for example, now you've got Raj Thackeray who has said, I will play the Hanuman Chalisa because Muslims are playing azaan through loudspeakers. Now, there will be those who will say that he is deliberately trying to incite a community or trying to stir a communal divide. Others will say he is making a political speech. It is not to be seen as hate speech. Therefore, these are grey areas, and the court tends generally not to intervene in the manner that they should. So today you can have these dharam sansas where various remarks are made that most people will see inflammatory, but certain states won't. How do you therefore see where does the buck stop? Does it stop with the police who've got to act swifter, or does it stop with the courts who've got to put in exemplary punishment, or indeed our constitution makers who maybe have to amend the constitution?
No, I don't think we need to amend the constitution. To my mind, the provisions under the Indian Penal Code are sufficient. Yes, as Mr. Sundaram rightly points out, that they are bailable offences. Issue is not that. Issue is that even with 3 years imprisonment, these offences are not being taken seriously by the courts. Nobody is getting convicted, even being sent to jail for 3 years.
Why?
You start sending people to jail in 10, 20, 50 cases, everybody will stop. But the judges are not, and mind you, these, it's not right to say hate speeches are not defined. It's not necessary. For example, Section 298 very categorically says in IPC, uttering words with deliberate intent to, hurt the religious feelings of a particular community. Now, it's very, therefore, it's very understandable. Everybody understands what all these provisions mean. To my mind, most of these speeches which are given are not only violative of, the bailable provisions of the IPC, but they are very always generally accompanied by open threats. For example, recently this sadhu in Uttar Pradesh from his car was openly telling people to, attack Muslim women.
But he's been arrested. He's been arrested. FIR was filed. He'll be arrested. But the problem is he'll be out on bail in a week's time.
Correct. So I feel that, even if it is a bailable offense, the court can always take, a seriousness of the offense in mind and can refuse to release him on bail, saying that what you have done is something extraordinary.
No, but under what section? Section? These are bailable offences.
No, just listen, Rajdeep.
Yes.
I know that they are bailable. You have said so 10 times.
Yes.
But the judge has a duty to set the trial forthwith. What is there? He has made the speech. Speech is already on record. The police has video of all these speeches. The court can set the trial within 1 day and say that I am going to pass the judgment immediately. You did it in Rajasthan when some foreigner was raped, or in Goa when some foreigner was raped. And you did it as in
So you're saying fast track it. You're saying fast track it.
Exactly. See, you have to, I feel, Mr. Sundaram may be right that what can judges do? I feel that judges have to send a very, very powerful message to all sides to the minority community, to the majority community, to every kind of a wrongdoer, that enough is enough. This country will not tolerate. Unless judges, judiciary in unison, from Supreme Court to the Magistrate Court, all stand up and take a serious view of the matter, I think we have lost the plot.
You know, those are strong words from you, because Aryama Sundaram, part of the problem is that these words are not just uttered by ordinary citizens. These are being uttered by people in power and influence. The kind of comments that are made by, you know, there is these constant dog whistles that are put out in the public domain. Now, you and I there could be a debate whether that dog whistle constitutes hate speech, but the signaling is clear. The problem is that the courts tend to back off because the courts perhaps feel that this is a contentious political area that they don't want to enter.
I don't think that's quite it, Rajdeep. Let me explain something. You know, you've got to give me just 1 minute on this. You see, the whole problem here is, and it's a ridiculous situation, but this is the situation. On the one hand, the freedom of speech and expression, which is a fundamental right, which of course can be restricted. Now, when you're restricting it, the question is, all right, was the speech of such a nature that will come within one of the restrictions under Article 19? Or, I'll give you a simple example. I stand up and say a particular religious tenet of a particular religion is something which I find very deplorable and should not be followed. I say so. Now, that's an opinion. That's a freedom of speech. But if I say that, look, people who are professing a religion which has this kind of tenet should all be violated, should all be hanged, should all be moved against, their houses should be burned, then I'm inciting violence, then the sections become applicable, I can be proceeded against.
But those are precisely some of the comments that were made at a Dharam Sansad in Uttarakhand. The violators got away and made the same comments a few months later in Delhi.
Again,
so there's no deterrence.
This is what I'm trying to say. You know what happened in the United Nations has formed a special body only to look into this, into saying, how do we ensure that hate mongering can be proceeded against and stopped without curbing the freedom of speech? And they've come up with the theory that if the speech is such that it incites to divide, to commit a violence, then it should be restrained, this freedom of speech should be restrained. All that's fine. But please make the law stricter.
Okay, so
while I appreciate Mr. Dave's wish that we have a fast-track court, we all know the problem. We all know the ground reality, how long cases take to be heard. And my point is, legislation should come in making this a very serious offense.
But who's going, you know, you make a strong point, and I want to give Mr. Dave a final word on this, because at the end of the day, who legislates are parliamentarians. Often who are responsible for making these hate speeches, especially during election time, it's our politicians. Now they will say they are making political speeches, they are fighting elections. So the lines get blurred because unfortunately politics and religion in this country have got mixed in a deadly cocktail, Mr. Dave. Unless our politics changes, there's very little our courts can do.
Let me first tell one thing, and I disagree with my distinguished friend, Mr. Sundaram at all. I mean, freedom of speech is, of course, there. Everybody knows freedom of speech exists in this country. But also, the provisions of the Indian Penal Code exist. If you have therefore violated the law prima facie, then merely because there is a freedom of speech guaranteed under Article 19(1)(a) does not mean you can't be proceeded against. I mean, it's a very clear-cut line. You have crossed the line. You have therefore prima facie committed an offense. Your offense is registered against you. That's the end of the matter. So I don't think freedom of speech should really be viewed in such a way that you have a license to, commit offenses. No, that's not
at all, Mr. Dave. That's not what I said.
No, that's what you mean.
What happens is one has to look into the speech to see whether it is such as to violate that right of freedom of speech and to say that it's a misuse.
No, but we've just seen a Delhi High Court say that an observation, not an order, desh ko ek gaddaro ko maro will be viewed as an election, could be viewed as an election speech. We are going to see the manner in which the speech is made. So, Mr. Dave, the problem is there is a lack of definition. The clarity is needed. Will the courts provide it?
No, Rajdeep, no. Section 123 of the Representation of People Act treats this as a corrupt practice, and the candidate is liable to be disqualified straight away. I mean, judges perhaps don't know the law. There is law. There is nothing required. There is no definition required. There is no amendment required. There is no constitutional amendment required. All that we need is to apply the law and apply it as vigorously and as honestly as we can.
Okay.
And judiciary has a bounden duty to do so. And I must say with greatest regret, judiciary is not doing so. And take for example this Delhi case. The statement by Mr. Anurag Thakur is clearly a most provocative statement. He is liable not only under the IPC but also on sedition charge. He should have been proceeded, and for the judge to say that he said so laughingly and therefore it should be ignored is a disgrace to judiciary. Is a disgrace to judiciary. I am really shocked that any judge can make such an observation in open court. I think judges need far more sensitivity than this.
Okay.
And it did result in violence. It did result in deaths of innocent people and loss of property. So I think judges, Supreme Court really must now come down heavily on these judges, must tell them what the law is once and for all and ensure that judges implement the law. When they want to do it in certain select cases, Supreme Court does it all the time. But I'm surprised Supreme Court is not taking, suo moto cognizance of this very serious challenge that this country is facing today.
Okay, let me leave it there. Strong words both from you, Mr. Dave, and a more cautionary note struck by you, Mr. Sundaram. Two views, but I appreciate you joining us. I hope this debate is carried forward and we are able to find a way forward, because that is what we want. This hate must stop. And it must stop, and the judiciary has a role to play, as indeed does the media. And I'm going to say that today openly. It's time that the media also introspects and looks at the kind of toxic debates that we put forward at times on prime time. I appreciate Aryama Sundaram, Dushyant Dave, both of you joining me here at the top of the news today. Now,